as we mentioned, how can a company be liable for decisions if somehow it's not a company, if by accident or otherwise it didn't fully incorporate or legally incorporate? An example would be if a shareholder and the incorporator or the promoter somehow failed their duty to fully and legally incorporate the company with the state's corporation commission by the omission of paperwork or the omission of an annual meeting of some form. Do the courts then have the ability to work around improper incorporations? On PowerPoint, in the PowerPoint for Chapter 36 on page 30, you'll see your answer. The courts have the ability, under what's known as the de facto rule, to treat the attempted formation like a company until at least the company is fully fledged. Another power the courts have, so we can understand, is their ability to rule that the company did exist, even though it didn't, under the doctrine of estoppel. In other words, that a company exists, and you can't say it didn't. That's called corporation by estoppel. As an attorney, I handled one such case. I represented creditors who were unpaid by the debtor company. However, the debtor company did something odd. It raised the defense that it had been defectively formed. That is, indeed, it was not a company. The debtor, the owner, the principal individual behind the company, claimed that the so-called company didn't have to pay this debt to my client as it was never a proper company. Corporation by estoppel refers to one who contracts or deals with an entity as a corporation. Thereby, that company, my client, the creditor, admits that the entity is a company, and therefore the other party, the debtor, should be estopped to deny its incorporation. Well, in our case, the debtor argued, you can't sue us, you can't sue the company, because there was no company. And again, my client, the creditor, acted, and they all acted as if there were one. It turns out the debtor's companies failed to file the proper paperwork with the State Corporation Commission after the initial rejection of its articles of incorporation were filed. My client claimed that the company should pay their bill, even though the company failed in a number of aspects in its formation. Indeed, the owner called himself an incorporated, an Inc. He signed with his title, such as president, and he had started his articles of filing even though they were rejected. And so for all purposes, he acted like a company. But there were no shareholder meetings, no board of directors appointed. In essence, he was trying to act like a company, but was not a company. And the courts held that corporation estoppel doctrine here applies. If you act like an owner, like this owner, then you've created a de facto company, and you cannot avoid liability. The company cannot avoid liability, even if it did not legally exist. Thus, my client won judgment, and we could attach, through a judgment lien, the imputed assets of the company. Note that, by comparison, we've previously studied a similar concept, the piercing of corporate veil doctrine. My client was not trying to sue the debtor, an owner, as a separate person or individual who set up a sham company. The ill-formed company had purchased capital. It had titled assets, which my client received a judgment against the debtor, the company, which then if we received a judgment, it could then use to sell off. In other words, it could then sell off any assets that the company had with that judgment as a judgment lien. And unfortunately, in this course, we do not review judgment liens or sheriff's sales or writs of execution, things that happen post-judgment to satisfy that judgment debt. The chapter's review of the types of ownership through stocks is well defined, and I'm not going to go over definitions in the lecture. I do encourage you to read the definitions carefully and distinguish each form in your minds, as there is far more complexity here than what appears on the surface. Furthermore, the larger the company, the more corporate stocks that they issue, the more issuance becomes a complicated and convoluted matter. For instance, some stocks have voting powers, some don't, and some can vote only after certain types of stock vote. So do be careful as you read through these definitions to try to look for clarity in your understanding.